with the roll call if you like.
Sure.
All right, wonderful. Thank you all so much for attending the second meeting of the ad hoc committee to discuss the project disclosure of agency legal materials. If this is your first time or you haven't popped in before, my name is Alexandra Saibo. It has been truly my pleasure and honor to be staff counsel for this project since November of 2022. And at this time, I'm just going to briefly turn it over to ACUS Chair Andy Foyce to say hello to everyone.
Thank you very much, Alexandra. And I just want to add my welcome to everyone to this very important working group today. And welcome literally to people who are zooming in from around the country and around the world. Thank you for your attendance, your participation last time and anticipated this time. And I very much look forward to the progress we make today under the wonderful leadership of our co-chairs, whom I thank as well. So thanks very much. Back to you, Alexandra.
Thank you so much, Andy. We really appreciate it. And as we did last time, we're going to go ahead and proceed with roll call for the members of the ad hoc committee. After I'm done with roll call, I'll introduce our project consultants. And as we've done before, we happily ask you to unmute yourself when you hear your name called. Please let us know that you're here so we can be sure that your microphone is working. If possible, I know not always possible, if you could also pop on to camera so we can see your wonderful face, that would be much appreciated as well. So starting the roll call, we start with our wonderful committee chairs, Aaron Nielsen.
I am here.
Wonderful, thank you, Aaron, and Roxanne Rothschild.
I'm here.
Excellent, thank you both. Next up, I have John Allreed.
Here.
Thank you, John. Next up, Jen Dickey. Jen's not here yet. Next up, I have Claire Evans.
Good morning, I'm here.
Wonderful, thank you, Claire. And next up, Bill Funk.
I'm here.
Wonderful, thank you, Bill. Next up, Amy Grace Tardy. And next up, Ted Hunt.
Present.
Thanks, Ted. Next up, Bert Kapler.
Good morning. Hi there.
Good morning, thank you. Next up, Renee Landers. Erica Litzen. Albert Lynn. Mitch Plave. David Pritzker.
I'm here.
Thanks, David. Kate Todd.
I'm here. Good morning.
Good morning. Thanks, Kate. Miriam Vincent. Miriam, we know you're here. Miriam is having some voice issues, so thank you so much. And she's going to pass along some comments from Nara when we get to that point. All right. Is there any member of the ad hoc committee present at this time who did not hear their name called? Okay, hearing none. Thank you all so much. Oh, I'm sorry. Go ahead.
Sorry, Alexandra. This is Noelle Green, EPA.
Thank you so much, Noelle. And is there any member of the ad hoc committee at this time who did not hear their name called?
This is Sheila Portanova from ACUS.
So much, Sheila. All right, great. So
Hi, this is Toby Dorsey from the Executive Office of the President, Office of Administration.
Nice to see you. All right, so I will happily at this time introduce our project consultants. We have a few of them in attendance with us here today, starting with our lead project consultant, Margaret Quokka.
Hello.
Thanks, Margaret. And Bernie Bell.
Hi.
Hi, Bernie. Thank you. And Carrie Colianese.
Present.
Thank you, Carrie. All right. So with that, I will happily turn it back over to Roxanne and Aaron to officially get us started in the meeting today.
Thank you, Alexandra. As I said, my name is Roxanne Rothschild. I'm the co-chair for this project. Aaron Nielsen is the other co-chair. Aaron very kindly took the lead at the last meeting, so I'll be taking the lead at this meeting. Can you hear me okay? Okay, great. So I'm just going to run through the script to remind everyone of sort of the ground rules for how the meeting works. So I'll be reading through this for you. Please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, though, I'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat if you would like to speak. Personally, I prefer the hand raise feature because it's easier for me to see. So if you can do that, that'd be great. Otherwise, put it in chat. I will call on you in best order I can for the people who have raised their hands, and then you can unmute yourself when you wish to speak, but please then remute yourself when you're done speaking. I'll also ask that ACUS members and their designated alternates use the webcam when they're talking because that facilitates conversation. With respect to attendees other than the ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, we will consider calling on such attendees at appropriate points and will presume that committee members consent absent their raising an objection. If any participant would like to speak, please do so by indicating in the chat feature or using the hand raise function to wait to speak until I call on you. You can then unmute yourself and then remute yourself. For all participants, please use the chat feature only to indicate whether you'd like to speak, or for committee members and their alternates, vote or to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the ad hoc committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels are allowed to vote. Please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. All right, that's it for the introduction. Did anyone have any preliminary comments before we get started? Okay, well, to get things started here, at today's meeting, we're going to be walking through the draft recommendations. But before we get to that, we would like to go over 2 or 3 issues that were pinned for further discussion. We had 3 issues that were raised at the last meeting that we wanted to think a bit more about. One is whether or not the recommendations should cover the issues of communications from the president. Others related to issues having to do with OLC. And the third was general counsel opinions for agencies. One thought here was whether or not we should have a straw poll to get a sense from everyone as to whether or not we should keep these provisions in or perhaps just jettison them right from the get-go. So how do you feel about doing a straw poll at this point? Okay, I see a thumbs up. So I will take that one at a time. So rather than everybody voting on all 3 of them at once. So with regard to the provisions in the recommendations that relate to disclosure of legal materials from the president's office, please vote if you would prefer that stay in. And so raise your hand if you prefer that to stay in the recommendations.
Is this just committee members who can vote on this?
Yes, that's correct.
Okay. Well, I mean, if you're trying to take a straw poll, a lot of us here will have something to say at the plenary if it doesn't go the right way. So you may want to be interested in that, but I leave that to you.
Well, we can also talk about these things. Okay, well, thank you for that vote. Let's vote now for those of you who are committee members who would like to see that provision removed from the recommendations. Alexandra, I'm assuming you're keeping account.
I am.
great.
We have a very, very clear vote difference for those questions.
Okay, so you can all lower your hands. So the next straw poll vote would be for the Office of Legal Counsel or OLC. Please raise your hand if you would like to see that those provisions stay in the recommendations. Okay, so I'm counting 3. Now, if folks would like to if you'd like to lower your hands so we don't have a miscount. So now if you could raise your hands if you are in favor of removing the OLC provisions from the recommendations.
I'm sorry, my hand is up because it took me a while to find the raise hand feature. So I was voting yes.
Okay,
Thank you for that clarification, David.
okay, I think that's everyone who's voting. So you can lower your hands now. Assume you got that, Alexandra. I should have asked before I.
Yes, thank you. I appreciate it.
Okay, then the last one is whether or not GC memo or opinions, and that would be GCs for individual agencies, their opinion, legal materials, whether we should take those provisions out of the recommendations at this point. So anyone who's in favor of keeping them in, please raise your hand. Okay, and then anyone who's in favor of, I'll let everybody lower their hands. Anyone who's in favor of taking the GC opinion provisions out of the recommendations at this point. Okay, so it looks like the GC provisions are going to stay in. Doesn't mean that we won't discuss that in detail and how, et cetera. But just thank you everyone for participating in just a quick straw poll because it may save some time here. Okay, so
We are still going to discuss these, are we? Since this is just a straw poll.
yes,
It's not a decision.
yeah, no, it's not a decision, but at least we know what direction people are headed. And we're going to work through all of the recommendations regardless, but at least we know where the majority of people are at this point. But thank you for raising that. Okay, with regard to the recommendations, Alexandra, I assume you've got a version of the recommendations that has, oh, Alan, I'm sorry, you had your hand raised. Did you want to speak?
Yes, I did. Thanks very much. I might have spoken before. I have a general comment about that applies to several of the recommendations. And that is, I didn't notice that the word indexing is in the recommendations. It's part of A2, and it's a very important function, particularly with regard to what the courts can require to be done. But it's also important if these legal materials are going to be accessible in any meaningful sense of the word. And to the extent that we have general counsel's opinions, or for that matter, OLC opinions that are not public, but are because they're withheld for some reason, the indexing of them are particularly important so people know what to ask for if they think they're being wrongfully withheld. So I wanted to make the general comment now, and perhaps the staff can think about this for the next round. I don't want to interject it into every one of the discussions here, but I think it's important, and I will raise it at an appropriate time if it doesn't get included. Thank you.
Okay, so you're essentially suggesting that even if indexing is done, it should be done not just of those documents that are disclosed, but of those that are also withheld. Okay. All right, thank you.
Yes.
Okay, so then next, Alexandra, I presume you've got a copy of the recommendations that incorporates folks, or at least reflects the comments that have been made. Do you want to share that?
Yes, I am hopefully going to be sharing that right now. And please let me know if you can see it.
Yes, I can see it.
Wonderful.
Okay, I have to get it bigger on my screen here. Okay, so in some ACUS projects in the past, we have spent some time walking through the preamble section of the recommendations, but given that we spent the entire last meeting talking about this subject in general and people's thoughts in general, if it's okay, I think we will skip straight to the actual recommendations here. Alan, did you have your hand up again, or? Okay, all right. So if that's okay with everyone, we can go straight to the language of the recommendations. Does anyone have a comment on that? Okay, so what the fine folks at ACUS have done for us is they have taken the recommendations that were in the report itself and rewritten them ever so slightly into more ACUS language and put them together as a recommendation for us for the discussion today. And so we'll walk through this and you can make recommendations as to anything that you think should be different with the language or anything that concerns you want to discuss. So we'll start with the beginning, the proactive disclosure of agency legal materials, and number 1, that Congress should amend. Does anyone have a comment on this number 1 provision? Professor Bell. Oops, I think you're still muted.
Thank you. I do have a question about this. So the text requires that the evidentiary hearing be legally required. And I'm not sure what legally required means. Does it mean legally required by statute so that it mimics the APA formal rulemaking requirement? Or does it mean, does legally require both include statute, regulation, or some other agency policy? So exactly how broad is the term legally required? And just maybe just so I could, I'll just say kind of what my overall perspective on this is, which is that we as consultants tried to avoid reducing the amount of stuff that and legal materials that had to be proactively disclosed. And my concern is actually that this actually cuts back on the amount of material that has to be proactively disclosed. Thank you.
So am I correct that you're pointing out a situation where the slightly revised recommendation doesn't exactly align with what was in the report? With the addition of the legally required aspect?
Well, I was assuming that the intent is different from the report. Our report recommended that every opinion and order be released, whether precedential or not, and whether I don't think it mentioned evidentiary hearing. It certainly didn't mention legally required. So my sense is from the comments and the drafting that this is meant to cut back on the consultant's recommendation with regard to the breadth of this proactive disclosure requirement. At least that's how I read it. I may be misreading it.
So does anyone who wrote this have a comment on it? Normally I would toss it over to the consultants to weigh in on the language, but since this is different from what you recommended,
well, maybe Margaret has a view
you have a
because
comment?
she was more, she really worked on this adjudicatory materials section.
Roxanne, I'm happy to jump in and explain at least why it's drafted as it is. As you can see, Alexandra has expanded the comment from our friends at EPA. Yeah, as Bernie mentioned in the report, it's broadly written to apply to final opinions and orders. A concern was raised that it should be narrowed to apply solely to orders and adjudicatory matters, which are subject to the formal adjudication provisions of the APA. We drafted this a little broader to align with previous ACUS recommendations that speak more in terms of legally required evidentiary hearings as opposed to simply formal adjudications under the EPA. But this draft is meant to reflect that comment, not to put a thumb on the scale, but just to tee up language for discussion by the committee.
Okay. Professor Bell, did you have anything more you want to say about that?
I think I'm fine. I'll leave it to the committee to, I just wanted to raise this.
Okay.
Flag this for the committee.
All right, thanks. Alan Morrison?
Yes, thank you. I want to focus first, the word regulated, I'm not sure is the right word. I think it's probably governed, but that's a small matter. I take it what you're trying to deal with here is the fact that the word order in the APA is extraordinarily broad. And everything an agency does, including issuing a permit or approving a grant, is an order. And what this is trying to do is to say which categories. And I think what you're trying to get at is the categories are Social Security, prototype categories are Social Security and immigration decisions, which are evidentiary hearings are required, but they're not 554 hearings. And if that's right, then this, I'm not quite sure that it legally require. I think it's required issued after an I think it should be issued after an opportunity for an evidentiary hearing, because you don't want to say that there has to be an evidentiary hearing because there might not be one. There might be judgments on the pleadings or whatever else it is, but there's still an order. And I don't have all the exact words, but I think that's what you're trying to get at. If that's what you're trying to get at, then I'm okay with what you're doing. We can look at the actual words when we get back to the next time. Jeremy, is that what you guys were trying to do?
That is correct. The terms regulated and consist of were taken directly from recommendation 2016-4, which dealt with this category. So that explains the language, but that's the intent, is to include the type A and type B.
Also, in the next sentence, I don't know that the right word is disclose. Maybe you want to say post or make available to consistent with the overall heading of number 1, because disclose is sounds like if you make a request, they got to give it to you. And I think that I don't want to get it tied up in a lot of other words. And right. Other than that, I'm okay with that on number 1, 1A. Excuse me. Thank you. Hand.
Okay, next, Bill Funk.
Yeah, I have to apologize for not having been at the last session that I couldn't make. But I'm concerned about the idea that every Social Security disability decision is going to have to be proactively disclosed. I see Alan shaking his head no. I mean, the question is, and every immigration, I mean, it seems to me that there's something about what should be proactively disclosed is precisely that which will be useful either to the government or to the public to see. And the vast majority of these low-level decisions don't qualify for that. And I just don't understand why we want non-precedential decisions to be proactively disclosed. And maybe somebody can help me. And Alan, I see your hand up, so help me out.
Section
Yeah,
2. Section 2.
Alan next.
Yeah.
Alan Morrison.
Section 2 answers the question. That's the exception for all of the ones that Bill doesn't think should be. And maybe we need to make it a little more prominent, but that's, I think, the answer.
Okay, next, Carrie. I'm going in the order they're popping up for me, so I apologize if this is out of order. So Carrie's taken his hand down, as has Margaret. I presume that's because Alan Morrison stated what they were planning to say. Carrie, did you want to jump in?
I took my hand down because I thought you had called on me.
Great.
No, I did want to flag that as the same point that Alan raised, certainly for Bill's objection. But I also wanted to highlight something that I think did in Alan's comments that did not get reflected in the edits to 1A, which was that it was not issued after an evidentiary hearing, but I think I heard Alan say issued after an opportunity for an evidentiary hearing. But as to Bill's point that this could sweep in far too many orders that are not really relevant to the public, that's the point of the next recommendation.
Okay, thank you. Next, Allison Zeev.
I just wanted to respond to Bill briefly because we litigated this issue in New York Legal Assistance Group versus Board of Immigration Appeals in the Southern District of New York and the DC Circuit. And the reason it's important to make all the immigration decisions public, even when they're designated as not precedential or unpublished is because the agency and the courts still have access to them and still rely on them and cite them. So it turns out that everyone has access to them except the immigrants, which is now going to change as a result of our victory and settlement in that case.
Right. Thank you. Margaret Koka.
Yeah, I just, on top of what Allison just said, which I agree with and which we explore in the report, I just wanted to emphasize the findings of the consultants that in our research, we came upon many examples where the full corpus of agency decisions made in adjudications were useful to the public in understanding trends and agency positions that are, repeatedly taken, but not necessarily part of an official policy that's been published or disclosed. And so we found many examples where there was really no substitute for seeing the full corpus of decisions, and many agencies that do in fact disclose the full corpus of decisions that they engage. And we did in fact, as Carrie pointed out, create what's now labeled as, paragraph number 2 as this sort of alternative compliance mechanism precisely for the situation, what we think of as probably a narrow situation where those would not be useful to the public, that an agency could come up with an alternative way to comply with the requirement.
Thank you. Next, Ray Peeler.
Hi, thanks. So on number 1, before you get to the subparts, it strikes me the way this is written, one could argue whether it's subject to the other exclusions and exemptions that exist under FOIA. And so that would be a real issue if there was a requirement for us to publish things that were otherwise subject to a FOIA exemption. So I think it would be helpful to include that language, assuming that that was not the intent of this recommendation.
Thank you. Do any of the consultants want to comment on that? Carrie.
It's a great point. I mean, the report is very clear that all of the recommendations that we're making are not intended to expand or change in any way any of the exemptions that are currently applied to FOIA. So it's a good point. It applies certainly to this one recommendation language in 1A, but perhaps you want to, put a prefatory recommendation in, subject to, all of FOIA's exemptions, the following recommendations for Congress would apply, or something like that. I think it's a point that will bear on everything.
I think that's a very good point, and you're right. The report makes it very clear that the intent is that the FOIA exemptions don't go away and would always be considered. But to the extent that the recommendations are to be a standalone document, I think your suggestion that putting some sort of prefatory statement right up front would be a good idea. Does anyone have any language to suggest? Before we get to that, I'm going to call on Bill Funk.
I don't have an answer to that question. First of all, I want to thank the people for answering my original question. Now, considering FOIA exemptions, it would appear to me that at least in a lot of Social Security, disability, and immigration cases, there might be personally identifiable private information that would be in the decision itself about the person's medical condition, about the person's relatives abroad that might be mentioned in the immigration decision, that might actually be exempt, would be if it was required under, if it was a FOIA request, it could be edited out. But I suppose you don't want somebody having to edit each one of these things before they're proactively disclosed. So I'm a little concerned about how that might work. And again, apologize for not being here last time. Maybe this was all answered. And I don't know if this would be covered by section 2.
Thank you, Bill. Next, Jennifer Dickey.
I was just gonna say that I think by making the recommendation that it should amend A2 to require, that is like clearly intended to, leave in place all the existing FOIA exemptions, because they're putting it into the part of the statute that is subject to those exemptions. Like if you scroll down in 552, you get to B, this section does not apply, and then lists all the FOIA exemptions. So I think that by explicitly calling out that statute, that's what the consultants were clearly intending to do. In terms of language, to make that clear, you could say, subject to paragraph 2 of this recommendation and all existing FOIA and all existing exemptions to just, FOIA or whatever, for all existing FOIA or all existing exemptions found in, 552B or all of that would be, I think, sweep in the FOIA exemptions, but it may be that there's something broader intended with respect to other, I know there are some common law doctrines that prevent disclosure and things of that nature.
Thank you. Thank you, Jennifer. Professor Bell?
Yes, just to respond to Bill's question, this is already an issue for agencies as far as parts of decisions that include information that can be withheld with regard to various FOIA exemptions, particularly privacy. And we learned in the course of our meetings with the consultative group that we had, that agencies have found ways to address this. I mean, redaction is one way. One could also have administrative law judges write opinions in ways that don't unnecessarily go into private information. Another approach might be, and this might require some work, but you could also anonymize some of these opinions, right? So instead of using names, you could use initials for parties, that sort of thing. I think in some agencies, in some contexts, although it probably wouldn't be as applicable with regard to Social Security cases, say, if there's information you want to protect that's not necessary to us deciding, then don't provide it to us in the first place. So I think there are options in addition to the option of having people go through and redact private information in each decision.
Great, thank you very much. Allison Zeev?
Thanks. I wanted to suggest not adding anything about current exemptions to point 1, because as Jennifer said, if you amend A, it doesn't, everything in 552A is subject to the exemptions in 552B. So I understand it's meant as a clarification, but it's actually would be sort of confusing to tell Congress to write in A that A is subject to the exemptions in B, because that's what the statute already says. And so it's just looking at A separate from the rest of the statute, that the question of how exemptions apply would arise, but in context, it would never arise, because B exists and applies to all of A, and indeed currently applies to all of A, which is also why I think it's not something that we or the committee needs to worry about in considering what additional material should be that we want to recommend should be included in A, because the need to go through and redact A to in light of the exemptions in B already exists for everything that's in A. So to that extent, we're not doing anything new. So I think it's just not a concern that should be written into recommendation 1. I think it would just be more confusing than helpful. Thanks.
Allison, thank you. I think you have pointed out a particular issue that's unique to this project. Most ACUS projects are just coming up with best practice recommendations to agencies, and we're trying our best to explain to the agencies what we mean. But you're pointing out this is actually statutory legislative changes that we're suggesting, and so thank you for pointing that out. Carrie, did you have a comment?
Sure, just following up on Allison's, I think, very persuasive observation and comment. Maybe the way of dealing with this would just to when you go back and revisit the preamble, to make it very clear in the preamble that preface that would obviously apply. It does indicate it there. Maybe that's adequate. Maybe because we didn't go through the preamble already, that you know, that's why this has come up, but it could be addressed perhaps adequately in the preamble.
Okay, great, thank you. Did anyone else have any comments on this opening section? If not, I actually have a comment. With regard to 1A, where the final opinions and orders issued in adjudications, we've made some edits to the language where it originally said, I'm sorry, could you scroll up a little? Thank you. We originally said that each agency should disclose any such opinion or order, and an issue was raised saying that disclose may make it sound like people have to ask for it. But really what this section is proactive disclosure. And I would say that proactive disclosure is more, using that term is more accurate than changing it to make available, because again, make available, makes it sound like somebody has to ask for it potentially. Whereas the point is it should be posted, period. That's my thought, is to go back to disclose, but say proactively disclose instead of make available. Margaret.
I just had one brief final comment on this, which is as a structural matter, I think we wrestled with the question that in some cases, it seems like the existing language of A2 may already require these things. It's just that it's never been interpreted. There's been very scant interpretation on many of these points. And so to some degree, we worried about suggesting that these were new requirements so much as clarifications in some instances, or specifications where maybe the statute isn't adequately specific. And so I worry a little bit that the way it's currently drafted says, you know, it should be amend this provision to require these things as if they're all brand new requirements. And that may very well not be the case. I'm not quite sure how to solve it, but the reframing sort of set that question up more starkly than, you know, we tried to be a little bit more, I think, deliberately ambiguous in our draft. So I just wanted to flag that as an additional issue.
Okay, great. Thank you. Jeremy.
Yeah, no, it's a great point. And we wrestled with this in drafting. So we did add footnote 7 to sort of get at the point that no matter what language we've used here, we're not coming down in this recommendation with a definitive interpretation of what this current statute requires, but merely saying whether or not it's currently required, this is what should be explicitly required. I don't know if that solves the issue, but at least that was the intent there.
Okay, Professor Bell.
Yeah, just briefly, one way we might address that is in the first sentence, Congress should amend the statute to and then clarify or require. So just adding the word clarify or might do the trick as well.
Okay, thank you. Alan Morrison.
I had an alternative, Professor Bell's suggestion, to make it so that it specifically requires. That would be, I think, the same goal.
On the thought that we're not saying it doesn't currently require, we're just saying it needs to be more specific about it.
Voila.
Okay. Anyone else have any other comments on 1 or 1A?
I'll just note really quickly, hopefully you all can see it on my screen, Carrie's point about the preamble language. We do in fact state that pretty clearly in the preamble. So the exemptions to FOIA's requirements, you know, all reforms should be interpreted in light of FOIA's current exemptions. Just wanted to make sure I flagged that and that you all could see it on my screen.
Yes. Okay, Jennifer Dickey.
So are we gonna, I guess this is a process question, are we planning to vote on some of this language? Because I preferred, I think it was Professor Bell's clarify or require language, because specifically suggests to me at least that this is all required. It's just now you're specifically doing it as opposed to generally requiring, and I don't know if that's accurate or not. So I kind of preferred being more agnostic about that. And then I found the response to the request about the language on 552B like persuasive. So I mean, I suggested it because someone asked for language, but I am perfectly fine proceeding without that language.
Okay, so you'd be fine with taking out that sentence.
Yes,
Okay,
and
no,
I
good
would
point. We can vote on the language for whether specifically require or clarify and require, I think is what it was. But first,
Clarify or
Bill-
require.
okay. Clarify or require, okay. Before we get to voting on that, Bill Funk?
Yeah, I wanted to go back to the preambular language with respect to interpreting in light of the exemptions. I found that language to be very unclear. I mean, I think if you want to get across the idea that all the exemptions do apply to the matters that we are asking to be proactively disclosed, I think it should say that explicitly. Don't say it should be interpreted in light of. It makes it sound like that's sort of a gloss on it as opposed to an actual requirement applicable to it. So I would reframe that language in the preamble to be clear that indeed the exemptions apply to what would be proactively disclosed.
Okay, so yeah, so we'll flag that for further discussion. And then we'll finish up with 1 and 1A here before we get back to tackling that, because that could take some more discussion. Does anyone else have any other comments on 1 or 1A before we vote on whether to use specifically require or clarify or require? Any other comments? Okay, so for those of you who would prefer that the language say specifically require, please raise your hands. Okay, and then how many, for those of you who would prefer clarify or require, please raise your hands. All right, clarify has it. So thank you, Alexandra. We'll make that change. So, okay, so I think we're done with 1 and 1A. So we can move on to 1, unless Aaron or Ted, you had a comment? No, okay. So we can move on to 1B. Does anyone have any, I'm sorry, Aaron, did you have a comment?
Yeah, I did have a quick comment on 1A. I agree with Jen. I'm not sure that we ended up in a place that makes a lot of sense. I probably would still prefer that we just said legally required, because otherwise issued after an opportunity. Agencies always have the ability to give you an opportunity. So are we saying after a legally required opportunity, in which case we're back to legally required? So I personally would just go back to where we were before, but I don't feel strongly, and I don't claim to be a huge expert on that, but I'm just a little bit confused.
Alan Morrison.
So regarding, I have a comment on B, but on Aaron's comment, the concern I had, Aaron, was principally that it looked as written is that as originally written, you only got to an order that had to be published if there was a required evidentiary hearing. And I think we were trying to determine the categories of cases and those categories of cases, whether they had an evidentiary hearing or not, those opinions and orders had to be brought forth, Social Security and immigration. And I'm okay with adding a legally required opportunity for, if I can't remember, I guess that's in there now, well, a legal required opportunity for an evidentiary hearing would be fine with me.
Aaron, did you have another
Yeah,
comment?
that works for me.
I will throw out there one comment, which is, do we need the term legally required? Could it just be or otherwise issued after an evidentiary hearing? I know that at my agency, for certain types of matters, it's up to our regional director to decide whether or not to do a hearing or just make it, just issue a little, I shouldn't say little, issue a decision on the matter. So it could be that we just want to say following an evidentiary hearing. I'll throw that out there. Alan Morrison, did you have another comment?
Yes, I mean, I'm not sure about what your comment about your hearings, but that gets back to the other problem of, if you don't have a hearing, then you don't get if you don't have an evidentiary hearing, then you have an order that doesn't have to be published, made available. And that's what I was trying to get away from.
Okay. Bill Funk?
Well, I'm back to the same problem that Bernie Bell expressed in the beginning, which is, I don't know what you mean by a legally required opportunity or a legally required evidentiary hearing. What about a legally required hearing? Doesn't say evidentiary. What about a legally required public hearing? Doesn't say evidentiary. I mean, is it legally required by due process? I mean, I just, what legally required, it's a very unclear standard, I think. So I like the way that Alan Morrison had it in the beginning, but in any case, I'm concerned about what legally required means.
Okay. Carrie?
2 points. One, specifically on this difference between just legally required hearing versus legally required opportunity for a hearing. I take it Alan's earlier point is that there may be times when an opportunity for a hearing is required, but a party, for example, waives that right to have the hearing, and that the disclosure requirements for the agency should not hinge simply on whether someone may or may not have waived their right to a hearing. The second, though, observation, and I guess it might alleviate a little bit of the concerns that that Bernie and Bill have mentioned about what does legally required actually mean. I just want to call attention to other recommendations, and we're intending these as a package, other recommendations that would allow agencies to customize and answer for themselves what legally required means through either their affirmative disclosure plan or the the opportunity to create some bespoke exemptions. What we're really aiming for, I think, at least speaking from my understanding of the consultant's report and consultant's process, is to try to create a default that is indeed broad, maybe even at times perhaps a little bit spongy, if you will, at the margins about what the borders are, but give agencies then the chance to customize this to their particular circumstances. So what legally required means at the NLRB may be something different than what legally required means at the Department of Transportation. And agencies really should be directed by this legislation to answer those questions, define them clearly, and disclose to the public how they are defining these terms.
Thank you. Does anyone else have any other comments? And it sounds like we may not have 100% agreement on the language as it's currently phrased. Does anyone have any other comments before we take a vote on it? So in terms of the way the phrasing is right now with the edits that are in place, please raise your hand if you're okay with the language as it is currently stated on the screen. That's overwhelming. Okay, so does anyone have any suggestions for how to change it that would make it acceptable? Professor Bell.
Yeah, let me suggest something. I don't have language that will fix this, but it seems to me we kind of agree on the concept, but not on how to craft the language. And given the limited time that we have, maybe someone should, or some group should go back and try to take our discussion, figure out better language, and then we can move on to other things, because it's hard to draft in committee in this form.
Yeah. Yes, as much as we try to wordsmith as a group, that can be difficult at times. So yes, let's put a pin in this and we will take a crack at this offline and come back later with proposed language. Thank you. Next, let's move on to 1B. Does anyone have any comments? Ellen Morrison.
I don't understand what the communicate word functions there. To whom is it communicated? How is it communicated? Do you have to send it to somebody else? Is it enough in the agency? What do the drafters mean by communicate?
Okay. Does a drafter wish to comment on that, or should I go on to Burke Kepler? All right.
I can comment briefly if you want.
Sure.
The idea was that these were not merely internal documents deciding not to bring an enforcement action, but rather decisions that were communicated to the regulated entity. And so that was the intention, was to ensure that these were already external documents that had been communicated to the relevant party, such that we were not reaching internal deliberations not to use agency resources, even though there's a violation of law or something along those lines.
Okay, great. Thank you so much, Margaret.
Can that be clarified?
Sure.
I'm fine then.
Okay. Burke Kepler.
Yeah, well, actually, I think we're kind of getting to the same point. I mean, this was the subject of one of the concerns I think that we raised with respect to the objections, because we do have a number of those kinds of internal deliberations that would reflect a written decision not to enforce one of our authorities, but it's not the kind of like formal declination of prosecution or formal closing memo or so forth that I think maybe the consultants had in mind. So I guess maybe the question is there a way to make it clearer that this is in fact, those kinds of things that have been either affirmatively communicated or even publicly communicated versus internal deliberations?
And this may be a very good time to look at Burke's written comments. Alexandra, would you mind showing that? We're only seeing part of it here.
Sure. Just give me a moment to swap out the screen shares.
Oh, sure.
I can give you a quick summary, Alexandra, or if you're, I mean, I can speak to it while you, I mean,
Great, actually. Thank you.
Yeah, I'll I mean, I think to unpack the concerns I think we raised, I mean, I think there's a couple of them. At the Federal Trade Commission, all of our investigations are non-public. And so some of those investigations lead to public enforcement actions. Some of them don't. And we do not necessarily publish the decisions not to proceed with an enforcement action. And there are a couple of good reasons for doing that. I mean, one is to keep the identity of the target non-public, and there are, I think, policy reasons why we've done that. Disclosing that, I think, sends sort of either two mixed signals, neither of which is entirely accurate. One, that we have a good reason for not pursuing this entity, or two, that we've chosen not to do so, and it's not exactly a declaration of innocence or a declaration of non-liability. It's a declaration that we're just not choosing to move forward with a given target. So the bottom line is, I think we have these materials. We think that having to disclose them could be slightly pernicious, maybe a better way to think about it. And so just the way it's written suggests that those were the kind of things we would need to now affirmatively disclose. And that's something I think we're concerned about.
Great, thank you. Margaret?
Yeah, I just wanted to flag that this, as it was redrafted, has substantially, if not perhaps massively, narrowed the original recommendation that the consultants made, which actually recommended that orders include all written enforcement decisions that either have a legal or practical effect on and have been communicated to an individual or entity outside the agency. That was our original. And then we said such decisions would include written assurances not to enforce, such as waivers and variances. This was not meant to be about waivers and variances, but rather about enforcement decisions that had been communicated to a party outside the agency. And so I don't know if that was the intent, but as I'm reading this now, this basically reaches grants of exemptions and waivers, but not actual enforcement actions. So I'm flagging that because I don't know whether that was an intentional narrowing. If it was, then, you know, it's obviously your prerogative, but the way it was originally drafted is substantially different.
Okay. Yes, I had noticed that as well, Margaret. I had some concerns about the recommendation in the report in terms of the fact that it would cover enforcement decisions, such as those that Burke was talking about. But then when I saw the version that ended up in this document, I realized, oh, well, it's much narrower now. Maybe I'm not as concerned. But I don't know what the decision was in making that change. Jeremy or Alexander, do you have any thoughts on that?
Yeah, no, it was purposeful. It was meant to, based on the discussion at the last committee meeting, you know, take the recommendation that was presented by you all and balance it against the concerns that were raised at the last committee meeting. So it was intended to strike some balance, and instead of using a phrase like enforcement decisions, actually give some examples of the kinds of decisions that we're talking about here. But again, that's for committee consideration.
Okay. Anyone else have any comments on section B? Ted Hunt.
Yes, I'm just reading this now again. It sort of seems like the second half of B is talking about a different category of documents here. We're talking, and first half seems to be talking about enforcement, or at least decisions not to enforce. And I sort of have the same sort of question about the narrowing of that there. But the second part of it talks about advisory opinions that apply generally applicable legal requirements to specific facts, and rest of it basically seems to be suggesting that agencies should disclose guidance documents, which I think is fair. So I'm just questioning why this is all kind of lumped together into one B and one paragraph is B, because it seems to be two separate categories of documents, and I would probably split that second one out separately. And I think you know, it makes sense because talking about advisory opinions that apply. So essentially, you're talking about guidance documents. I'm not sure if you want to make that clearer or not there, but that's just my suggestion. So.
Well, you raise a good point. If it reads like it's trying to talk about guidance documents, there's this whole other section on guidance documents. So perhaps we don't need to be talking implying that we're talking about it in two places. But thank you for raising that. Jim Tozy.
I have a question of how many agency personnel are voting relative to non-agency. I think the point that Mr. Kapler made deserves some attention. I think with the people that I know that are very concerned about an agency that does some work but does not conclude to take any action, and we get tons of letter because things are published and the publicity is killing us. It's not a trivial thing to a lot of firms. And so I don't have a horse in this race anymore, but I'm wondering the mixture of this committee, if it's mainly academics versus people in the troughs.
Good question. I'm in the trough. I'm sure
it's balanced. It was intended to be balanced, and the way it was constructed is balanced, and that's also why you see we have two co-chairs, one of whom is a government member and one of whom is a
no, but I mean, how many voting on this cause? I meant because I saw a lot.
I couldn't tell you.
Yeah.
Alexandra.
Did you want me to run?
No, I'm just wondering. What I'm amazed is what I'm saying. You need to do the counting. That federal agencies that when I worked with would want pre-judgment materials disclosed like this, and maybe because I'm not in an agency anymore, but I only heard one objection, and that may be the case now, and I'll go along with it. But I'm only expressing my surprise that other agencies wouldn't share Mr. Kapler's concern. Because if there's only one dog biting, doesn't mean there's not a lot of other dogs interested in the issue. That's all I have. I have no vote, so go ahead. Thank you.
Okay, Bill Funk.
Well, I just wanted to respond to Jim and say, I'm an academic, but most of what I think about here is that in the 5 years that I was in the Department of Energy, and all of this would have applied to me, and I would have had to comply with it. So I bring both those horses to the trough, as it were. And I think we take care of that by saying it's only things that have been communicated to a member of the public that would have to be proactively disclosed. So if anything that's just an internal document would not come under this provision.
Anyone else have a comment on section B? Jim, did you have more that you'd like to say? Okay, Margaret?
Yeah, I think now that I understand this as sort of a compromise or deliberate choice, I'll just raise that to me, it doesn't make a ton of sense to require the publication of decisions not to enforce, but not decisions to enforce. So the original proposal would have covered things like fines and penalties and other enforcement actions actually taken. And this one only applies to things where the agency has decided not to enforce, which seems almost backwards to me, where we would be most concerned with knowing when an agency is using its enforcement power affirmatively. So I just raised that because it seems dissonant, but obviously, if this is the compromise that is agreeable, then this is what it is.
One thing I'm going to say before I ask Carrie to speak is one of the concerns that came to my mind in reading this section and the original language of this section as well is it's not always for our agency an issue of are we deciding to enforce or not enforce. Usually it's the question is, do we believe there's a violation of the act or not? And so if in the investigation that's conducted, the decision is made that we don't have sufficient evidence to show that there was a violation of the act, that's where we decide to decline to issue a complaint, for example. And that's what was concerning me a bit is would this provision be covering those decisions? Not that we're saying, well, we're not going to enforce against you and we're giving you some sort of waiver. It's more that, well, we don't feel that there was a violation, but there'd be something written that would say that. Would that fall into this category of disclosure? That's just something I had been thinking about. Carrie.
I was going to agree with everything Margaret said, except as the author of a paper on unrules, her suggestion that that the application of obligations through enforcement is more important than the opposite. That I might just want to flag a note that both I think are important, and I agree with her that both should be covered.
Okay, thank you. Professor Bell?
So a couple of points, one of which is in response to something that you just brought up. So you described the situation at the NLRB where decisions not to enforce really in some ways seem to could reflect at least a determination as to what parties' legal obligations are. In that situation, that would seem to me to be legal material that people, regulated entities and both on the employer side and union side should know about. If we're talking instead about situations in which, well, maybe there's a violation of the law, but we don't have enough resources, so these are the way we allocate our resources, that seems to be less to me of something that would qualify as legal materials. So in some ways, we're talking about types of documents that could either reflect what the laws or reflect completely different considerations. The second point I would make is just to caution that again, the FOIA exemptions apply here And so at least one should consider how those play into what the impact of this will be. So there are FOIA exemptions with regard to law enforcement materials. And some of these could potentially fit into that, including the exemption for, I think, prosecutorial guidelines. So it's important to keep in mind that the exemptions are still at play, and that may or may not alleviate some of the fears expressed with regard to 1B.
Okay, great, thank you. Bill Funk?
I'm responding to the things that Margaret and Carrie brought up. It would seem to me that if there's a decision to enforce legal requirement against an individual, that's going to be the beginning of a proceeding which ultimately will result in something that would have to be proactively disclosed under one of the other provisions. Whereas a decision not to enforce, that's sort of the final thing, and that's when it ought to be disclosed. So the idea, every time you're going to start a proceeding against somebody, you'd have to proactively disclose that. I mean, that's my confusion. So I see Kerry shaking his head and perhaps can explain that to me.
Is Kerry?
Yeah, I don't think that is the intent here, or even was covered in our committee's report. Margaret may want to weigh in on that, but I think the concern that Margaret was pointing out to is the way 1B is now drafted. It takes out a provision that would do exactly what you said, which would cover those written enforcement decisions after the enforcement action is taken, unless you think that that's already covered by 1A as some kind of adjudication. So
that's what I think. That's what I thought. Yeah.
Okay. Margaret, did you? Yeah.
Yeah, go ahead, Margaret. Sorry, I'll skip over Alan Morrison to go to Margaret.
Apologies. Yeah, I reiterate, I think the intent was not when those were the beginning of a proceeding, but when effectively it was the end of a proceeding, because there is no evidentiary hearing that's accompanying it. So when there's an enforcement decision that's made where that's the whole action without any further process to come, which is often the case, that those are the final decisions, for all practical matters, because there's nothing that goes on afterward. And that's frequently the case.
Thank you. Alan Morrison.
Oh, let me see if I understand this correctly. The FTC conducts a major investigation, but it's not public. Obviously, the target knows about it. And at the end of the investigation, the FTC sends a letter saying, we have closed the investigation, period. If Margaret, would that letter, because it's communicated to the target, have to be disclosed? And even though nobody knew about the investigation before, they might get some bad publicity from it. And B, the letter itself says nothing of substance. It's not like a waiver of an exemption. I'm fine with the rest of them in there. I don't see what the public gets, and I can understand why companies would be very unhappy about saying that the FTC has closed the investigation. Am I mistaken?
So I don't know, that was not the intent. So the intent was that for those decisions not to enforce, they were affirmative grants of waivers, dispensations. I think Carrie probably can address this better than I can, so maybe I'll stop there. But so maybe this is a wordsmithing question, is to avoid that situation that you're talking about, Alan, but that was not the goal. Carrie?
Yes, Carrie.
Yeah, it was certainly not the goal or intent here, I think we could wordsmith it, or again, remember that for an agency like the FTC, if that's part of their practice, they can, in their affirmative disclosure plan or in their bespoke regulations, make that exception and make that clarification for why that type of document would not apply. And I guess just to go back to the point about whether other kinds of final decisions are covered. I take it from, just to expound on Margaret's earlier answer, an inspector's citation, for example, would not be covered, as I read it, under 1A. But it would be nevertheless probably closing out, unless it was contested, some kind of enforcement action. And that was covered, I think, under the way the consultant report recommendation had read.
Thank you. Alan Morrison.
No, as I read the current recommendation, it would not include the FTC example that I gave. And we could maybe make that clear. The word enforce, well, I'm not sure what the word problem is, but as I read it, it would not include that, but it would include the other things that Margaret mentioned. As far as the other one is concerned, the fine, presumably, if it's a settlement agreement, they agree to it, and that could easily come in under a settlement agreement that they agreed to pay such and such a fine. And so I guess I think that this is one of these things is if it doesn't come under one of these things, it may come under another point that Carrie made before. We have to keep that in mind as we're looking at these individually. That's all I got.
Yes, and I would say, in reading the language as it is now, I would, since it's a decision not to enforce a legal requirement, I don't think it would cover those situations like I had described where my agency decides not that we're not enforcing it, but that we find that there's no violation. So I would say that those decisions wouldn't fall under this, but that's my take on it. So since there doesn't seem any more discussion on B, should we do a vote on this language as to whether or not people are okay with the way it's currently constructed? Alexander and Jeremy, is that the next step? Yes, okay, getting thumbs up. So in terms of section B, as it's amended on the screen, please raise your hand if you're in favor of keeping this recommendation as written. Okay, looks like we've got the votes. And then please raise, after everyone lowers their hands, please raise your hand if you are in favor of not including section 1B in the recommendation. All right, thank you everyone for voting. And with that, we will move on to section 1C, the written opinions by chief legal officers. Does anyone have a comment? Oh, Alan Morrison.
I agree with this recommendation, but I'm concerned issued by its chief legal officer. My memory is correct, and it may not be, that the IRS has the chief legal officer delegates to various other legal officers the authority to issue certain binding opinions depending upon the subject area. And if they haven't, they could. So maybe we could say, rather than by or under the direction of its chief legal, or under authority of its chief legal officer, something, I don't have the right words, but I want to be sure that they can't avoid it by delegating it down to somebody else.
Thank you. Good point. Let Alexandra write something very clever here. Thank you. Carrie.
Just to suggest the language, Alexander might want to issued by or under the authority of its chief legal officer.
Okay. Anyone else have any comments on this section? Carrie, or did you have another comment? No. Aaron.
So here's just a question. Do we need to say anything about the authority of the chief legal officer? Couldn't it just be written opinions that bind agency officials? I mean, presumably the person who can bind it is generally going to be the chief legal officer. But if there's some situation where it's someone other than that, but it still nonetheless binds agency officials, wouldn't we also want that disclosed?
Thank you. Bill Funk.
Well, I think Aaron's point is a good one, but my question was going to be, what's the reason for saying acting under statutory or delegated authority? I mean, if indeed the opinion does bind agency officials, I mean, presumably there must be some authority for it, but I don't know why we have to say acting under statutory or delegated authority. Maybe somebody can explain why that limitation is in there.
Aaron, did you have another comment?
I did not. I'm lowering my hand now. Sorry about that.
That's okay. Jennifer Dickey?
So in response to Aaron's comment, if you were suggesting the removal of like chief legal officer, I wonder if that would take us outside of legal opinions. Like, I wonder, I mean, maybe written opinions conveys a legal notice, but like, I'm imagining a supervisor who just says like, I'm going to make this policy. That's not like a legal policy, but he's just decided for, for whatever reason, like we're for reimbursements or we're going to do something like that. That's not really what I think we're getting at. Like maybe he just wants to avoid even the appearance of a problem. So he says like, we're always going to stay at this, these government hotels or whatever. I don't know. So I think chief legal officer or like those acting under authority, like focuses it more closely on legal opinions. I agree with Bill Funk that I'm not sure that we need the acting under statutory or delegated authority language, which both with the use of the two authorities starts to feel cumbersome and also raises questions about written opinions where they're acting outside their statutory authority. And like, I would think we would want those disclosed. It also embeds like a legal issue, right? Like, were they acting under their statutory or delegated authority or not? So I think it would be better to eliminate that parenthetical phrase. But I would be in favor of keeping chief legal officer.
Yeah, I'll let Aaron answer for himself. I wasn't sure that Aaron was saying to get rid of chief legal officer, but I'll let him answer that.
I mean, I was, but
Oh, okay.
I think Jen's point is well taken. If we wanted to, we could say written legal opinions that bind agency officials in the performance of their duties. If we want to avoid that, I mean, I guess it just, otherwise it's gonna be really cumbersome because we're going to talk about like, what if it's sub-delegated and all that sort of thing. When really, I just want to know if it's binding.
I'm just going to throw out there the suggestion that perhaps instead of just saying written opinions, but written opinions and memoranda issued by or under the authority of, because in my agency, at least, when our chief legal officer issues these sorts of opinions, it's styled as a memorandum, and it goes out to all of the regional offices. So this is what you have to do now with the board's new interpretation of the law. That's just how we work. Bill, did you have a comment? Right. Anyone else have any comments on this section? Burke.
Yeah, I mean, this was an area where we had submitted an objection as well, and I think this recommendation has changed a lot since the last version of the recommendations that we had seen, and it looks like it's intended to streamline. But I just kind of wanted to clarify. This looks like it's trying to get to more of the chief counsel, like chief IRS counsel kind of opinion, where you have, in the words of the prior recommendation, like a corpus of opinions that essentially is a standing body of law within the agency that is binding and accepted by the members of the agency as binding authority. If we can get more to that kind of notion, maybe the idea of like a standing accepted corpus versus memoranda, which is getting more into like the day-to-day legal advice, that I think is where our concern about this recommendation came from. I'd prefer that. I'd prefer whatever we can do to wordsmith this to get to more of the chief IRS counsel language.
Thank you. Renee Landers.
So what if you change, first of all, I'm sorry I was late, but something came up this morning, but what if you changed, instead of saying written legal opinions and memoranda, because, I could foresee us getting this like long list of documents, what written determinations or written legal determinations. So then we're not so regardless of what the agency calls it, if it's a document that binds the agency officials, then it should be disclosed.
That's an interesting suggestion because that aligns with the effort that's made in some of the other sections where it says, let's get away from the nomenclature that we use to call these documents and actually focus more on the substance of the documents in deciding whether or not they need to be disclosed. Burke, did you have another comment? That's okay. Okay. Shannon Pazur.
Thanks. I just wanted to know, from the Department of Justice's perspective, I'm not entirely sure what this covers.
Shannon, you're breaking up a little bit.
I'm sorry. Can you hear me better now?
It's better.
Okay. I was just going to say from the department's perspective, it's not entirely clear to me what this would cover, since we are an agency basically entirely made up of attorneys. I'm not sure what would fall into this category at all. And we also don't have a chief legal officer unless you're considering the attorney general to be that. That's again, they're, entirely, lawyer-led department. So I just wanted to flag that at least if there's anything folks had in mind that would apply to DOJ specifically, I could use some clarification, but I'm not sure how this would apply to our.
So I'm sorry, I had a little trouble hearing you. I take you're saying you're not sure how it would apply to your agency because of the term chief legal officer, whereas you have a different term for that function.
We don't have that. We don't have a general counsel's office or something like that. That's just not how the department is organized, and I'm just substantively not clear to me what materials this would apply to. Is this getting at, enforcement priorities, attorney general's directives as to where we should put our resources? I mean, that binds us in a way, but there's discretion. I'm just not sure what this is intended to cover.
Okay. Well, I could say, you could say hip hip hooray, this doesn't apply to us, because I'm just kidding. I apologize. Professor Bell?
Yeah, just briefly, I'm not sure whether the by or under the authority of the chief legal officer is in or out, but if it's out and it's just written legal opinions that are binding on the agencies, you may actually be backing into OLC opinions, which are binding on, or arguably binding on agencies. And I suspect you don't want to back into that.
No, I'm not trying to back us into anything or find ways to make this apply to us. I just want to make sure I'm not missing a way in which this is intended to apply to us that is not obvious to me on its face.
Thank you. Aaron?
Yeah, excellent point. I think we should leave in the authority of the chief legal officer language to avoid that concern. My mistake. Thank you.
Okay. All right. Anyone else have a comment? Oh, Jennifer Dickey.
With respect to DOJ, I would assume that this is intended to cover like the letters from the attorney general that he sometimes issues that say like, we're going to make this an enforcement priority, or we're going to we will no longer pursue. I mean, sometimes these might come from the associate's office too. And that's like the trouble, I guess, in DOJ is you're looking at, associate's office instructions on, I can think about like the sue and settle memos, corporate compliance issues from, the civil division chiefs or the criminal division, front offices. So there's a lot of things in DOJ that I agree with Shannon, are not clear here in terms of what we want from DOJ. And I don't know, I don't know how to specify, I guess you could say.
Could you add an S to chief legal officer to chief legal officers?
or it's equivalent, but then I wonder whether you still need to deal with the OLC problem, because what is the equivalent chief legal officer at the Department of Justice is, I think challenging.
Well, yeah, that would get back to the point that Carrie has raised of that each agency needs to create their own, as he calls it, bespoke plan for disclosure based on these requirements. Renee Landers?
So just following up on that point, you know, I don't read this as it's drafted as applying to a statement of enforcement priorities, because that's not I don't think that's a binding legal determination. I mean, I think we're really, I read this as saying, this is how we're going to do that, and a state, characterize certain things, but it's not it's not binding on on the agency because the DOJ could sort of look at a certain situation that falls within the category of the enforcement priority and say, oh, this isn't the thing that we're worried about, and, not take any action.
Thank you. Jennifer Dickey?
Well, I mean, I think if the AG says to the employees, like, we will not prosecute blah, 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 that binds agency officials, not in the sense that they are like legally bound out in the world, but like they are bound by their agency head has told them what they are allowed to do. And so I think that that's what they were trying to get at is, like if the associate's office issues a sue and settle memo that says you can't, or I don't know, I guess it's not sue and settle, I forget what it is, like some of the key TAM settlements or whatever. Sometimes the associate's office issues memos on, what you can do in terms of settling cases. And I think those would be viewed as binding on the officials who are carrying things out while at least that administration and that memo is in effect.
Thank you. Michael Hurst?
So I'm not, when you say I don't know what they were intending, I'm not sure if the they was the consultants or the ACUS folks. I don't think it's what we, the consultants, were intending. That is, this business about exercising prosecutorial discretion is really what B was about from our point of view. And the C is really sort of determination. The core issue covered by C is when the general counsel says, and the EPA general counsel says greenhouse gases are not air pollutants, so they are air pollutants, right? When the general counsel makes some determination about the statute under which the agency is operating. And that's why it's important for members of the public to know, because this is a kind of effectively binding statement of what the law is. And so I think going back to Jen Dickey's very good previous comment about, with regard to whether we limit it to chief legal officers, statements about, per diems and hotels would not be covered by this, right? Internal operating requirements are binding on agency officials, but not what this was aimed at. And it may even be, we want to say, bind agency officials in the performance of their statutory duties, or modify that language slightly to make that clearer. But the core idea here is not that this is a binding policy that the agency has adopted. And most of those don't come from the general counsel's office. They come from the head or other program officials, but rather that it is a statement of what the law is that would be valuable for members of the public to have. And that, I think that's consistent with what Burke was saying about the IRS as a sort of core case.
Great, thank you. Alan Morrison?
So I want to be clear that while I am strongly in favor of bringing OLC opinions out in the open, I don't think we should do it through the back door of C here. And I'm also not interested in going after when criminal division decides it's going to prosecute somebody or not going to prosecute somebody. So I think perhaps we could be clear. I'm not sure the word statutory is all duties are statutory in some sense. But if you added that bind the agency officials in the performance of duty as a matter of law, that would take out all these discretionary determinations and keep it away from the guidelines, meaning that that's how we interpret the statute, whether as a matter of law should go one place or yeah, that's fine. That's fine to put it there.
So then you're also suggesting taking out the word statutory in that sentence?
I don't care. I want to get the one idea in to make it clear what we're not trying to do is we're not trying to talk about enforcement discretion here. Although the law will obviously play a part in it as well.
Yeah. I mean, I think that your comment that statutory in that sentence may not really be necessary because obviously their duties should comport with whatever statute they're enforcing. Bill, did you have a comment? No. Okay. Anyone else have a comment? Oh, I'm sorry, Carrie.
Just going to reinforce, I think, something that has been said. I think Alan actually said it earlier. It's possible that some document might fall into more than one of these categories, right?
Mhm.
So I don't know that you need to be totally worried about making sure that C excludes decisions about non-enforcement that are just because they're covered by 1B. A document could be covered by 1B and 1C, for example. And the point is that it should be proactively disclosed unless the agency has, for some reason about the administrative burdens or the probative value of the document, declared that it need not be disclosed under its own policy that's also been affirmatively disclosed.
That's a very good point to the extent that the goal here is proactive disclosure. If something needs to be disclosed under one section and another section, it just basically says, yeah, it really needs to be disclosed. In terms of this section, does anyone else have any other comments on it or the language? If not, let's take a vote, I guess, as to the language of the beginning of the sentence where it says written legal opinions and memoranda / determinations. One of the questions is whether it says written legal opinions and memoranda, or it says written determinations issued. So for those of you who would prefer that it say written legal opinions and memoranda, please raise your hand. Okay, and then for those of you who would prefer that it say written legal determinations issued. So written legal determinations, please raise your hand. Alexandra, did you get a vote count on that? Okay, all right, well, thank you, everyone. And then so I think we're going with opinions and memoranda, is that correct? Okay.
That's correct.
Right, and then now that it says written legal opinions and memoranda, everyone who's in favor of keeping this section as it is now written, please raise your hand. Okay, and then everyone who's in favor of getting rid of this section altogether, please raise your hand. Okay, all right, well, thank you, everyone. Next section is D. Just a few words. Settlement agreements to which the party to which the agency is a party. Does anyone have a comment on this? I actually, first, before we do that, Alexandra, do we have a comment on that's been submitted that we should go over?
So there's a specific question for the committee here in the comment bubble that I just expanded that hopefully you all can see that by phrasing the question this way, we tried to incorporate some of the comments that were received on this particular provision. So this particular provision should engender a lot of discussion amongst the committee, I presume.
Yes. Okay. Bill Funk.
I've asked for motion of privilege or something that I don't know when the next meeting of this committee is scheduled. But I'm not going to be available for approximately a month from now. And so in as much as F had been something that was added specifically in response to my comment, and hopefully it doesn't have much dispute about it, but if we could take that up before we take up something that's more problematic and will take more time given the time of day and when the meeting's supposed to end, I'd appreciate it.
Sure. Does anyone object to us jumping ahead to discuss subsection F instead at this point? Seeing no objections, we'll discuss F, which Bill Funk had suggested being added, which is agency delegations of authority. Bill, did you want to speak to that at all?
Well, that's one, I think it's simple for agencies to do. And it's something that I think agencies are sometimes lax and lazy about actually making formal delegations of authority, which can get them in trouble. And by making a proactive disclosure requirement, at least make them focus on the fact that they do have to make a formal delegation for making agents final agency decisions. So that's the reason for it. I think it's simple to do and something that people should be able to see.
Alan Morrison.
I think I support this, and I have a question. Do you mean, does it have to be a written delegation, number one? And should we say that since we've used it written in other places? And two, does it have to be, you use the word formal, Bill, and I don't quite know what that means, but I mean, if I say to you, I'm your boss, and I say to you, I'm going to be out this afternoon, would you take care of any matters that come in and so forth? Are we worried about that? Or even if I send you an email and says that? Do they have any temporal limitations, or I'm just trying to figure out what it is, because I'm sure agencies will have lots of questions.
So are you suggesting it might be better to have it be written agency delegations of legal authority or something like that, Alan?
This is Bill's proposal. I don't have any views. I only have questions.
I mean, it would seem to me that if it was an oral delegation and that's all it was, if the head of the agency says to somebody, I want you to do this for the next, during my tenure here, make final agency decisions, and I'm not going to put it in writing so that nobody can see it. I don't think that's a good idea, right? So I'd leave it as it is on the assumption that people will make real delegations in writing, and by requiring a disclosure will make clear that it has to be in writing. So I think that's delegations of legal authority is fine. I have no problem with that.
Yeah, I think that might be a good edit, just in that I'm just trying to think for our agency what situations would arise. But I know that when a new chairman comes into our agency, they will often do a written delegation to their chief of staff for certain personnel administrative matters. And I guess it wouldn't be the end of the world if we had to put that out into the public, but it's probably of fairly little interest to most people. They wouldn't be surprised that a chief of staff has some authority to do some things. Anyway, any other comments on this addition, this provision? Well, thank you, Bill, for suggesting that we move ahead to this. Bill, was this the only one that you had suggested adding?
Yes, this is the only one I specifically added. I mean, somebody said G as well, but G seemed like a good idea, but it's not specifically what I was proposing. No, this F is really what I care about.
Okay, great. Thank you. We should probably vote, I suppose, on F. Everyone who's in favor of including F in the recommendation, please raise your hand. Okay, thank you. Everyone who is in favor of not including F in the recommendation, please raise your hand. Okay, all right, thank you. Let's go back to subsection D, the settlement agreements to which the agency is a party. Does anyone have a comment on this section? Allison Zeep?
I just wanted to say quickly in response to the comment on the side that I don't think it should be limited to judicial proceedings. Because sometimes the agency will settle in order to avoid judicial proceedings. And then those wouldn't be captured even if, if they waited a month to settle, there would have been judicial proceedings. And lots of times the settlement is a way to avoid litigation. So I don't think we should limit it to that. As written, it's all settlement agreements to which the agency is a party. So I would leave it at that. As to whether it should include agreements where the agency is acting more as an employer rather than as the federal government, if I wouldn't have an objection to excluding those, but I think I would do that by saying like except for at the end rather than limiting the broad language that's there. Thanks.
Okay. Alan Morrison?
Oh, under the Federal Tort Claims Act, the United States is the correct defendant in cases. Not always done that way, and the government often waives that. But and there are other cases in which the United States is a defendant for various reasons. I don't know whether we need to go into this detail or not, or maybe we could put it in a footnote to the preamble or someplace in the preamble that whether they're the real party in interest, whether they're formally the defendant or not. Sometimes the agent, sometimes someone will sue the head of the agency, rightly or wrongly or whatever it is. The point being that we obviously want to capture all of those and shouldn't be dependent upon what they happen to the name of the defendant in the case, or for that matter, the plaintiff in the case. And so maybe the staff can take care of that matter in the preamble. I don't think it needs to be in the actual recommendation.
Okay, thank you. Any other comments on this provision? All right, if we have no other comments, let's take a vote for in favor of whether or not to keep this in the recommendations. Those of you who are in favor of including section D, oh, I'm sorry, Renee Landers. Were you voting or you have a comment? So everyone in favor of keeping section D in, please raise your hand. All right, thank you. Everyone who is in favor of not including section D in the recommendation, please raise your hand. Kate, I think you had your hand up for being in favor, so I assume you're still in favor. Okay, great. Well, thank you. That was quick. All right, moving on to section E. Still have a few minutes left here. Memoranda of understanding, memoranda of agreement, and the other similar interagency or intergovernmental agreements that affect a member of the public. Does anyone have a comment on this section? Burke Kepler.
Yeah, just to say that we had submitted a comment about this, that there may be occasions when there may be non-public MOUs or MOAs for investigative contexts, and just to have an exemption or a recognition that there are circumstances like that where there are legitimate reasons for non-public disclosure. Maybe that's something that's embodied by the FOIA exemptions generally, like section 7A, but just wanted to put that on people's radar that there are occasions when these may not be public.
Yes, thank you. And I apologize for not pointing out that you had submitted these comments in advance. So do you feel that the language should be changed because of the exemption, or do you think that the regular FOIA exemptions would just come into play to keep those out of being required for disclosure?
Given all the discussion we've had about applicability of the FOIA exemptions, I think I'm fine with that. So I don't see a need specifically for change to this right now.
Okay, great. Thank you. Anyone else have comments on this section? All right, maybe we've just worn you all out, which is good. So let's all vote. I'm just kidding. So for section E, the memorandum. Oh, I'm sorry, Bill Funk, are you voting? Okay, so are anyone who's in favor of keeping section E in, please raise your hand. Okay, and anyone who is not in favor of keeping section E in, please raise your hand. Okay, so section E is in, and we've already addressed section F. Let's move on to the final provision under 1, which is section G, orders of succession for agency positions whose occupants must be appointed by the president with the advice and consent of the Senate. Does anyone have a comment on this? All right, oh yes, Ted Hunt.
Yeah, I guess I'm a little confused as to what exactly it means, orders of succession, where I guess it just depends. Every agency is really different, right? But our agency has 5 members that are appointed by the president, 5 board members, and they have certain terms, 5-year terms, and they can be reappointed under our statute for another term. And there's some holdover provisions and all that type of stuff. So I'm not sure what is meant by orders of succession, because it would cover our board members here. And maybe somebody can clarify that for me.
Jeremy.
Yeah, so we had included this bill in reference to your mention of acting appointments, but maybe this is not exactly what you intended. And if that's the case, then that's why this appears in this draft.
Bill.
Well, thank you, Jeremy. I guess that was what you were doing. And to answer Ted's question, which is orders of succession are when the person leaves, retires, dies, resigns, who takes over and takes that place. And for a member of a commission, the answer is nobody. There is no order of succession. That just goes blank. And there's just one less member of the commission. But for agencies where there are, in fact, in agencies with multi-members, there may be people like the general counsel who are appointed with the advice and consent of the Senate, but they do have an order of succession. That if the general counsel leaves, there's somebody else who can take that position, perhaps. It's the idea of when the person leaves unexpectedly, who takes over. That's what an order of succession means. And many agencies have them. The Department of Justice has them. And so I think that's a good thing to have publicly available, to know who's going to be in charge if this person dies or leaves or resigns.
Thank you for helping with that. I just guess I'm locked in my own agency here, where it doesn't really seem to apply to us because, as you said, it's because our members are appointed directly, and there's no order of succession. It's basically by statute says, if the holdover period ends, we don't have a member, basically. So anyways, that's fine. I appreciate your clarifying that.
Yeah, we're kind of in the same boat, Ted, where we have 5 board members who are presidentially appointed, Senate confirmed, who, when their terms end, they're done. There are no successors. But we also have a general counsel who, when the general counsel's term ends, there is a successor. And I believe under the Federal Vacancies Act, we're supposed to say who that person is, but all the more reason why it should be publicly said who that successor is, so that if it does happen, as we have had it happen, it's clear who's going to be acting at that point. But anyway, does anyone have, I'm sorry, Michael, you have a comment?
Well, only that, I'm all for this. It makes sense. It's just a drafting issue. As this colloquy is highlighted, there are positions whose occupants must be appointed by the president with the advice and consent of the Senate, for which there are not orders of succession. And to require posting orders of succession for every position that's a PAS position would just read literally require creating something that doesn't exist and shouldn't exist. I don't, maybe it's not worth worrying about, but maybe we don't have to draft about it on the fly, but it could be drafted to just make clear that, you know, where orders of succession are otherwise required, they should be posted, something along those lines.
Okay, great. Jennifer Dickey.
I think you could just say orders of succession issued for agency positions, and that would encompass only those that are actually issued, not like require them. And that leaves room for those that choose to do so, those that are required to do so, etc.
Thank you. Allison.
So adding issued concerns me because these things generally, that might make it seem like they have to be made public in some way. And the whole problem that G is getting at is that they're often not made public at all. So they exist like in somebody's file in the secretary's office or something like that, but they're not, they're created. I don't know that they're issued. I just want to ask if it's really necessary to qualify this in some way. I mean, maybe it is if people found it confusing, but for all these things, they only need to be disclosed. Then putting on this list just means if they exist, they need to be disclosed. Nothing about all of number one suggests that a document must be created. It's just about disclosing what has been created. And if you agree on that, then there doesn't need to be any revision or qualification of this. Just like for agency delegations of authority, if there is no delegation, it doesn't need to be disclosed. Anyway, just something to think about.
Thank you. Bill Funk.
I completely agree with what Allison just said.
Okay, Ted Hunt.
Sorry, I don't mean to. I guess I probably disagree with it just because the way it's phrased here, it says whose occupants must be appointed by the president. And so it's implying that every presidentially appointed and confirmed, officer out there needs to, there needs to be an order of succession that's disclosed. And that's why I think maybe issued isn't the right word. Maybe it's orders of succession for agency positions to extent such an order of succession exists. So I mean, I'm not sure. I'm just trying to draft on the, or maybe the order of succession for agency position that to the extent they exist. So I'm not just trying to.
Oh yeah, we're applicable.
Something like that. It's just to me.
You didn't get rid of issued.
Yeah.
I'm sorry, Ted. I didn't mean to talk over you.
No, that's okay. That's okay. Yeah, I mean, I'm just trying to come up with something that works because to me, it does seem to imply that there should be orders of succession for these types of officials. And I'm like, as people have said here, that there are some, like our agency doesn't have that. So, but maybe, I'm not gonna, it's not a hill to die on here. So.
Well, and to the extent that agencies don't tend to have a lot of presidential appointees at them, it probably would be much of a hardship for us to add to, for example, our About Us section of our website, where we'd say, for the general counsel, the orders of succession would be blank. For the board members, there are no successors who would step in at the end of their term. It would, the term would remain, or the position would remain empty until a new board member is appointed, nominated by the president and confirmed by the Senate, something like that. I mean, it would take very little for us, for example, to put something like that on our website.
Yeah, maybe like where applicable, it seems like that could be causing, I saw a lot of hands jump up when that got put in there. Maybe the word any orders of succession for agency positions, to me, that's better because it's just implying to the extent there any exist. But yeah, maybe that helps.
Bill is nodding, but Michael, did you have a comment? Yeah, no, I mean, I agree with Ted that the reason that I don't agree with Allison is that this one is modified to a particular set of provisions, unlike all the, settlement agreements and memorandum of understanding and agency delegations. Yeah, as long as they exist. But this identifies a particular subset. I'm fine with any orders of succession, blah, 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 or supposing we just said orders of succession, period.
because then Allison, I'm totally with you.
You mean get rid of the
Wait, I'm
rest
sorry,
of it?
did you actually want to remove that, Michael?
Well, it is the for agency positions whose occupants must be appointed by the president of the advice and consent of the Senate doing important work. If we just say orders, I mean, I don't know enough to know if there are orders of succession for other kinds of positions. If all orders of succession are by definition this,
There are.
then
we
it's
all
not
have
doing
to
any
do
work.
coop-
If it's,
Yeah.
if there are for other ones, I don't know why we're limiting it to these. And I wonder if we just say, you know, orders of succession.
Yeah, we all have to have COOP plans, continuity of operation plans that have detailed orders of succession for many of the positions in the agency. That's why I was saying it's not a heavy lift to do the PAS folks, but do everybody would be a lot more information.
Okay.
Well,
I'm fine with any. Then I think Ted had it right.
So we're at 1 o'clock. I don't want to cut anyone off here. David, how about we have David be the last comment for today's meeting?
The word that keeps popping up in this conversation is existing. And seems to me you might clarify what you're getting at to say any existing orders of succession.
Okay, thank you.
And maybe in connection with the suggestion to stop after orders of succession, perhaps orders of succession for agency positions.
Okay, I said we'd be done, but Alan, do you have a quick comment?
I don't like to disagree with David, but I think existing means that if they change the order around, they wouldn't have to publish it. I don't think existing does any useful work. I would suggest we not include it. But
I suggested it only because that's the word that kept popping up to discuss, to identify what we're talking about here.
I think
Okay,
any is fine.
So let's, why don't we, Alexander, should we put a pin in this for the next time? Just because there seems to be more discussion to be had on this as opposed to taking a vote on it. So anyway, I want to be respectful of everyone's time because 2 hours is already a lot to take from your day. Thank you all. Alexandra or Jeremy, did you have any closing remarks that you'd like to make?
No, just the reminder that the next committee meeting will be next Wednesday, April the 26th, same time, 11 a.m. Eastern to 1 p.m. Eastern. Thank you all so much. Really appreciate the fulsome discussion today.
Great. And thank you, everyone. And Aaron, if you had a second to stay on the line after everyone drops off. Thank you, everyone. Thank you for your active participation. Really appreciate it.
Yes, thanks. Great meeting. Great handling it. Roxanne.
Thank you. Alexandra, I didn't ask you to stay on, but I meant for you too. So, and Jeremy.